You are going live in now. Let's give a few minutes for them to log in. See this?
Yes, sir. Hello, everyone, and you're welcome to panel 7A of the Second African Arbitration Association Annual Conference. My name is Idris Mohammed. I'm speaking from Kaduna in Nigeria. I would be moderating this session. The topic of the session is high tech in international arbitration and its risk. This session shall look at the trends and needs of artificial intelligence in international arbitration, data protection, and the possibilities of adopting the General Data Protection Regulation in international arbitration, cybersecurity risk in international arbitration, and whether blockchain will be the innovative and uncertain force reshaping international arbitration. Given the level of development and access to AI in Africa, what, if anything, should be done to ensure that Africa is not left behind? With the COVID-19 pandemic, the use of technology has become imperative with all the protocols associated with the pandemic. Also, within these sessions, there will be 3 different polls to be used to stimulate the discussions. Participants are kindly urged to take part in the polls. To do justice to this topic, we have assembled a team from across different jurisdictions in the world. From Vienna in Austria, we have Anna Forstel-Schenk. Anna is an attorney at law with Binder Grosswagen in Vienna, Austria. Anna became an attorney at law in 2019 after obtaining a law degree from the University of Vienna in 2013. She has also completed her postgraduate studies with an LLM from the University of Pennsylvania in the United States of America. She also received the Wharton Business and Law Certificate from the same university. Anna is a member of the Young Austrian Arbitration Practitioners and is admitted to practice in Austria and the New York State Bar. Anna shall be giving us an introduction into the topic before we go into the nitty-gritty. Also in this panel is Nuno Albuquerque. Nuno Albuquerque is the founding partner of N Avocados, insolvency administrator and arbitrator, and a certified mediator. Nuno is registered to practice in Portugal, Angola, and Paris, and has extensive experience in commercial law, insolvency, restructuring of companies, sports law, arbitration, construction, and litigation. Nuno is a member of the Portuguese Court of Arbitration for Sports, Brazilian Center for Mediation and Arbitration, and a member of the Committee of Experts on Sports and Entertainment Industry of the European Arbitration Association. Nuno is also an ex-member of the Executive Committee of the Portuguese League of Professional Football and a member of the ICC Institute of World Business Law. Nuno has participated as speaker at workshops, seminars, and conferences. Nuno shall be giving us his perspective on new technologies and how they can be deployed in international arbitration. Also here with us is Gavin Dingley. Gavin joins us from London in the United Kingdom. He holds chambers at 5 Paper, and he has domestic and international practice, specializing in international arbitration, sports, and entertainment law. He's a member of both the English and Brussels Bar, and has right of audience before the Astana International Finance Center Court in Kazakhstan, and also before the DIFC in UAE. Gavin's commercial practice has focused on he has advised or advises international corporations and often acts as part of a large multi-jurisdictional legal team or as a sole counsel in Africa, Asia, and the Middle East. Gavin also has experience with post-award matters at the annulment and enforcement stage. Finally, and more interestingly, as we'll be talking on the risk involved in the use of high technology in international arbitration, is Tariq Badawi, who will be joining us from Cairo in Egypt. Tariq is a partner in Shahid Law Firm's International Business and Dispute Resolution, managing partner of Shahid Law Firm Sudan Association. Tariq has represented and still represents clients in trade, commercial, and investor state disputes, and has advised clients on transactional and compliance matters in several commercial industries across the spectrum. He is particularly experienced in media-related issues and is currently the lead Shahid Law Firm counsel in several international and regional disputes involving sports. He also sits as an arbitrator and acts as legal expert before foreign courts and international arbitral tribunal. Tariq is a member of the Egyptian Bar Association and also is a licensed barrister and solicitor of the Court of Appeal for Ontario, non-practicing. He holds several degrees from the American University in Cairo, the Cairo University where he got his LLB, and his LLM from Essex University. He's multilingual as he's fluent in English, French, Spanish, and Arabic. You would agree with me that we have a well-constituted team that would do justice to this topic. And without much ado, may I invite Anna Forstel-Schenk to introduce the topic to us before we get down to the nitty-gritty. Anna, the floor is yours.
Thank you, Idris Mohammed, for this very kind introduction. And I would also briefly like to thank the organizers for giving me this opportunity to be a part of this highly distinguished panel. As Idris has mentioned, I will be giving you a brief introduction and touch upon a couple examples of how technology is used in arbitration without going into too much detail with the individual examples, because those will be addressed later on by my co-panelists. I will structure my examples roughly in the order as you may encounter them during an arbitral proceedings. So at the outset, you will need to evaluate what your potential evidence is. So let's say you have a large amount of documents and you want to use technology to help you sort through those documents. What you can use is predictive coding. Predictive coding is an artificial intelligence tool that is used both for document review, but can also be used later on in the document production phase. Let's define artificial intelligence a little bit, since we'll be talking about that a lot today. Artificial intelligence is computer science that aims to replicate or simulate the human intelligence in machines. What that means, however, is that artificial intelligence can only be as intelligent as the people who program it. In the context of predictive coding, the way it works is that you take a sample of documents that is reviewed by a lawyer who is familiar with the case and familiar with the law involved. The lawyer then codes those documents as relevant or not relevant, and in doing so, trains a predictive formula or algorithm that can then be applied on a larger set of documents, which will filter down the relevant documents for you without having a human being who needs to go through every individual document. And the algorithm can be tweaked and made more accurate along the way. So now that you have established the base of your case, you know your evidence, now you want to know, are you going to win or are you going to lose? There are AI programs out there that can help you predict the outcome of the dispute. Those databases are increasingly used in litigation and are particularly attractive for litigation funders who want to establish whether or not a case is worth their money. One of those artificial intelligence softwares that is used to predict the outcome of disputes is Legalist. That is a database which uses millions of court records to help assess how likely a case is to win, and is used primarily for, which is used a lot by litigation funders. In the arbitration context, a similar AI program has been launched in 2017 called RBLex. RBLex also intends to give you a prediction of how much your arbitration will cost, not only about the outcome of the arbitration. The problem in the context of arbitration is, however, that the database is much smaller than with litigation. There are plenty litigation cases that are public and online and are accessible for those companies to train their AI software with. Arbitral awards, however, are most often confidential. So it will remain to be seen whether the arbitral institutions who do have access to relatively large databases with awards will in the future be willing to share their data with programs like RBLex. Without going into the risks too much, I already at this point would like to address, however, that artificial intelligence has a risk of bias. Like I said, the artificial intelligence can only be as intelligent as the people or the data used to program it. So that means if the data set used to program the artificial intelligence is biased, so is the artificial intelligence. And one prime example of this is a program used by some US court called Compass. And it's a program used to evaluate how likely a parolee is to reoffend. The algorithm is based, or so it says, or expressly based, let's put it that way, on age at first arrest, history of violence, your education level, history of non-compliance, and then they use a weight multiplier on those individual criteria. However, when the outcomes of the assessment by Compass were evaluated, it was shown that they are biased against African Americans, even though, of course, the algorithm does not make an express reference to ethnicity or race. And these risks will need to be addressed by AI programs in the future if they are to be used in dispute resolution context. Now let's assume we found an accurate AI platform. We have put in our case data. The prediction is you're likely to win. You want to proceed. Now you may want to file your claim with an arbitral institution, and many of those nowadays allow you to file the claim electronically. And especially during the last year and in the course of the COVID-19 pandemic, when many arbitral institutions were forced to start working remotely, many for the first time, the entire system of correspondence and submissions was moved from the old type of paper submissions to electronic submissions. Some institutions have taken this a step further and have moved from email correspondence to the creation of online case management platforms, which are cloud-based softwares that are used for file sharing and collaboration during the arbitration process. And those can also be used to grant not only the parties and the arbitrators, as well as the institutions access, but also experts, for example. To name just 2 arbitral institutions who have implemented such case management platforms, for example, the Stockholm Chamber of Commerce, as well as recently at the beginning of this year, the Vienna International Arbitral Center. Chinese arbitration institutions such as the Shenzhen Court of International Arbitration and the Guangzhou Arbitration Commission have taken this even a step further. Their case management platforms also offer the possibility to host remote hearings. And in doing so, they offer an intriguing feature, I think. They offer a voice-to-text technology, which means that during the arbitral hearing, there will already be a synchronous transcript of what is spoken during the hearing. And maybe in the Q&A session later on, we will have an opportunity to discuss whether someone has already had any experience with how well those softwares work or don't work. Remote hearings are probably the most prominent development in the last year. Many arbitrators were faced with the difficult decision, are they gonna postpone a hearing to, nobody knows, an indefinite point in time? Because even today, we don't really know when travel restrictions and restrictions on gatherings will be lifted. Or in the alternative, will they have a document-only dispute, or will they move the hearing online and hold a virtual hearing, which in the past has mainly been done for organizational hearings, but not so much for evidentiary hearings, which include the questioning of witnesses and the examination of experts. Speaking from an Austrian context, we have had a very prominent and widely reported Supreme Court decision in the fall last year, which has actually declared that holding a hearing remotely, even against the will of one of the parties, can safeguard the right to be heard and the right to equal treatment. Of course, you can not only hold the hearing online, you can also hold the entire arbitration online, so-called online arbitration, where all aspects of the proceedings are conducted online. Online arbitration is widely used for internet domain disputes. For example, arbitration administered under the Hong Kong domain name resolution policy. If you now want to take it even one step further in terms of technological integration, we can talk about blockchain dispute resolution. Blockchain dispute resolution was a mechanism developed or is seen as the mechanism of choice for smart contracts. So what does that mean? Blockchain is a digital ledger of transactions which can be programmed to record not only financial transactions, but almost anything which is of value to be recorded. Blockchain is a database that is stored not on a single location, but is spread across a network of millions of computers simultaneously, thus making it hard, or some would say impossible, to hack and corrupt. So what is a smart contract now? A smart contract is a contract that is written not in spoken language, such as English or French, but it is entirely in code. Thus, like a program, smart contracts automatically execute and enforce obligations. A very simple smart contract, for example, could be if you want to sell an item, the smart contract is programmed in a way that once the payment is received, the ownership is transferred. Of course, a smart contract can also be a bit more complex and can still give rise to disputes among the parties, which is where there might be a need to integrate an arbitration clause in a smart contract. In doing so, the parties could, for example, choose the arbitral platform called Clearos. Clearos uses crowdsourced adjudication, meaning that there are jurors that are randomly assigned to decide a dispute, and they are financially incentivized to decide a dispute coherently. Clearos defines a coherent decision as a decision that is in line with the majority. One could, however, debate whether this is really the right incentive to achieve a fair and correct outcome of a dispute. I hope this brief overview was helpful to give you an idea of all the different uses technology may have in arbitration, and I look forward to diving into the nitty-gritty, as Idris called it.
Thank you so much, Anna. That was a very brilliant exposition, and I'm sure our other speakers will give more flesh to your introduction. Just before we go to the next speaker, we'll be taking our first poll right now, and the poll will be coming up shortly. We would urge participants to vote on the poll as it comes up so that we could use it to gauge the feelings and to also direct the discussion into a proper direction. Okay, while we wait for the poll, Nuno, you have plenty of years of experience in the practice of law and also as an arbitrator. What would you consider? Anna has just mentioned some new terms that may sound as Greek to some of us that may not be so much, some of the participants and attendees that may not be so much into technology, blockchain, smart contracts, AI. Can you give us some more exposition on these new technologies and how they will directly or how they have already started affecting international arbitration? Nuno Albuquerque. Okay, our polls are up now before you come up. So it's the use of technology in international arbitration beneficial despite the attendant risk. We just give it some time for the votes to come in. Everybody seems to be saying yes to it. Okay, we have someone that is saying not sure right now. We have more than half of the attendees already voting, so we'll just give it 1 minute, and then we use the polling results to guide our discussion. So basically, what the attendees seem to be saying is that, yes, the use of technology in international arbitration is beneficial despite its attendant risk. Flowing from that particular perspective, can we now go to Nuno and for him to give us his perspectives and further elucidation on the new technologies and how they can be used in international arbitration. Nuno, how's Portugal today?
Thank you very much, Idris. Thank you very much, the organization and my co-panelists. when I start working, we didn't use it, even any computer. We write everything with the hand, with a pencil. This is true. Maybe you don't believe it. I'm not so old like that, but it was a few years ago. In real, I will share with you my presentation. I think it will be better. And the first thing I want to tell you, it's the reality that simply cannot be ignored, and the results from the immensely successful applications of new ICTs, it's coming. The implementation of new technologies leads to additional disputes and even new categories of disputes. Technology is used to assist IDR, to perform IDR, and to facilitate dispute prevention. This is not a matter of mere convenience. Maybe you all are thinking, okay, we all agree on this. Don't lose your time, man. And you are not telling nothing new. Okay, I know that. I'm sorry. Don't switch off. I know this is past. We must look into the future. And the future, it's now. I believe a number of alternatives to work have emerged that until now were not seen as viable. The justice system did not respond to the new challenge of the new technologies. We must think about how there could be an alternative response from justice. They are just ideas and thoughts and not suggestions. Think about what exists and how we can respond to those challenges. Imagine three different situations. A program with all the decisions of the Supreme Court that would allow to know through big data and the algorithms the probability of a certain argument being considered valid or unfounded in a lawsuit. Imagine that possibility and how it would change our practice. Imagine a second situation, a computer application that compiles all the previous judgments of a court and that was able to predict with 80% certainty the future verdicts in view of the data fed to it. Imagine also a third situation of a court that works exclusively online and in which about 80% of the cases don't go to trial and the rest are also done online. This is not a possibility for the future. They are the real present. They are not a chance for the future, but they are a chance for the present. This is a print screen for the LexisNexis page, an application, a program in which through legal analytics and the big analysis of court decisions, the system is able to obtain a series of outcomes, analyze case results, language standards, history of the situation. And it allows user to obtain information regarding judges and court decision, special through this application called Lex Machina, that gathers information about certain behaviors and as a result allows judicial operators to define a strategy or think about a substitution of who decides. The Lex Machine application uses legal analytics whilst viewing cases to analyze judge behavior and law firm involvement. This Lex Machina legal analytics provides the tools you can use to craft successful strategies, win or settle cases. It has digitalized all court decisions since 2009 and allows to predict of federal court decisions through analysis. Of course, you can't predict 100% of the outcome. Maybe you only can predict 70%. But the point is, you can do it. I will show you with a brief example of this work. You have here the main page. You can do legal research predictal guidance, litigation analysis, and brief analysis. We'll do a brief analysis. We put our document in the support doc or PDF. You drag and drop your file here. And after you step for the second stage, scanning the document, scanning for virus, and learning the document. Was a document I used last week. This is an escrow agreement we are preparing as a pledger and the lender. And I have all the document, the recommendation for some selected passage, for some judicial decisions. You have here the recommendation, the cases, all the document, some passage you can see some decisions. And you have a resume and extract concepts, the case recommendations. Maybe I found here 10 cases and the 2 key passages we have identified from your document, and the case recommendation and cited situations in the document. All the cases is cited in my document. So this is something amazing and very, very, very useful. And it's not only in the United States. For example, in France, you have a relatively recent decree was approved called data just, which established an algorithm purely digital, which draw up an indicative framework for personal injury compensation. The result is found by this algorithm, and this is by legal imposition. It's not a product for that is available. It's not something commercial. It's something created by a legal decree. The processing authorized by this decree aims to develop an algorithm responsible for automatically extracting and using the data containing in court decision relating to compensation for body injury. More specifically, it involves identifying the amounts requested and offered by the parts to the proceedings, the assessments proposed in the context of amicable dispute resolution procedures, and the amount allocated to victims by the courts. C'est un document écrit qui a été proposé par une commission nationale. I'm sorry for the French, but I think some of you could understand a little bit French. And it's not the end. In the other hand, there are already the so-called e-courts and electronic courts or online courts. They already exist in several countries, in Canada, China, Singapore, Australia. In particular, the example of a especially successful one in Canada, it's the Civil Resolution Court. You can see now in the screen, which is integrated into the justice system. It's not a private system. It's the justice system working. In other words, we are not talking about ADR, arbitration, or private solution. We are talking about a court that is included in Canada justice system and that has jurisdiction on small claims through a very intuitive system. When we see the image and the way they approach the citizen, it is open. The entire process is monitored. Lots of information, then a decision phase. This is a very intuitive system and very close to the citizen. And the development of big data and artificial intelligence is among all the world. France, Canada, England, but special, I call your attention what's happened in China. The China's courts have established 4 public platforms to make available court information to the parts and the public through the internet. China's court provided online litigation service for the past parties through the litigation service website, and now they are connecting them to the web applications. That is China Mobile WeCourt to WeChat, the largest mobile social app in China. China courts have developed many systems such as intelligent trial support system, trial speak recognition system, similar case pushing system, informatized case handling platform for communication and parole, and online data integration. All these assist judges in improving the quality and efficiency of their work. Chinese court have established a no-way system, a trial management system, connecting the courts nationwide, through which information about all courts, all judges, and all cases can be collected in real time. With this big data set, Chinese courts can analyze courts trials from all over the country in real time, assess the individual performance of judges, as well as evaluate the social and economic situation. Based on this, let me talk you about a book that is drawing the attention of the international community, the online courts and the future of justice, from Richard Susskind. Richard Suskind's most recent book sets forth a vision for the future role of online courts in resolving civil disputes, and why they will have a profound effect on the manner in which processing of disagreements and claims under law is likely to occur. This book is absolutely must read for lawyers and others interested in systems for making access to justice a reality in digital age. It roams well beyond mere practical consideration of the functions of online courts in small civil claims. In this book, Richard Susskind shows how litigation will transform by technology and propose a solution to the global access to justice problem. The courts of some jurisdictions are laboring under staggering backlogs. 1 million cases in Brazil, 30 million in India. More people in the world now have internet access than access to justice. Susskind shows how we can use the remarkable reach of the internet to help people understand and enforce their legal rights. So, a final remark to one question. Is the court a place, or is it a service? If is it a location, we need a building. If is it a place where a service is provided, a justice service, we must rethink how that service is provided. This changes the way we look at the problem, and then we can bridge the gap between fundamental rights and due process. In conclusion, we can see here on this slide that legal technology and artificial intelligence already exist for many different situations. Indeed, the future is now, and the benefits of legal technology in a legal department are many. The legal technology has arrived in terms of assisting lawyers to do things faster, better, and cheap. The existing technology may be limited for now, but the possibilities are intriguing, and the availability, quality, and price will all soon come together in products that are just too useful for in-house legal department to resist. Thank you very much for your patience.
Thank you so much, Nuno. That has been quite interesting and also enlightening. Let's go on quickly now, as I don't know whether he's still in London or he has run away from the hustle and bustle of London, but Gavin Dingley will be talking to us about the advantages of the use of technology in international arbitration. Gavin, where are you?
I'm back in London at the moment. Thank you very much, Idris, and thank you, Nuno. I think I'll start off with covering a little bit about what Anna mentioned to start with. So, as we well know, arbitral institutions have adopted a range of new measures so that they could continue to manage arbitration proceedings during the COVID-19 pandemic. And several leading arbitral institutions have since adopted electronic filings only and encourage the use of video conferencing for all the hearings. And what we must recognize that whilst these measures have been welcomed as allowing dispute resolution to carry on with the business as usual tag, arbitrators and parties must still ensure that these measures do not negatively affect parties' rights to due process. Because if due process is compromised, as we well know, the finality of the arbitration award could be jeopardized. Now, the framework for the advantages of arbitration is this. It's not new. It's been around as early as 2004 when the ICC task force was commissioned for an IT report, which was most recently revisited in April 2017. In the latter report, it outlined the benefits of IT in international arbitration and underlined that the benefits would outweigh the risks. It highlighted in particular that briefs with embedded electronic links to cited exhibits, testimony, and legal authorities could help the tribunal better understand and evaluate cases. However, the caveat was that it could be time-consuming and expensive for parties to prepare. In general, the report suggested that the benefits of greater IT use in international arbitration largely outweighed any risks. And the report itself argued that many of the widely available IT solutions were not used to save time and costs as effectively as they could be. Video conferencing, which some tribunals and parties remained reluctant to use for even minor witnesses, was considered as good an example of an IT solution that could easily cut time and costs in international arbitration. It's almost undeniable that the onset of the COVID-19 pandemic has fast-forwarded the implementation of the recommendations within this report by many years, and possibly to the arbitration community's advantage. I think without this sudden change, which has affected us all, we'd probably be still roaming around in the dark ages in some parts of the world. And I think it's certainly been at the forefront of our community to push forward and recognize the benefits of implementing these various mechanisms for litigation generally, and not just within international arbitration, but fundamentally, it is our community that has taken the lead on this for some time. If we look at the benefits of technology in international arbitration, what I'm going to touch on is just a few sort of generalized points. The first would be logistics. Undeniably, the advantages of remote arbitration hearings are numerous. While lengthy testimony does not necessarily translate as well as an online format, as some of us well know, it does promote a more time-efficient and focused hearing, which results in cost reductions for the parties. The novelty of an online format also allows for a more flexible dispute resolution process where parties can tailor the proceedings according to their requirements. International arbitration particularly involves significant travel and presents scheduling challenges which can delay the expeditiousness of a hearing proceeding. A remote forum allows proceedings to be scheduled in a more timely manner and avoids the costs associated with travel and accommodation. In addition to the cost and time efficiencies that can be realized through a remote forum, some participants may feel that their experience is enhanced as they are able to participate on equal terms with the tribunal and the counsel team, rather than only engaging from the back row of a hearing room, as many of us have experience of. Moreover, the availability of virtual hearings allows for a more diverse and greater array of options where the choice of arbitrator is concerned. The new system can facilitate arbitrators from Africa hearing disputes in Hong Kong, all with a simple provision of an internet connection. This will hopefully assist with enhancing diversity problems, which routinely plague the various panels at larger international arbitral institutions from across the globe, and add a greater diversity in the selection of arbitrators for those who participate. Secondly, we have the prospect of reduced hearing lengths. In the main, one of the perceived advantages of a virtual hearing is a more focused approach to the issues in dispute during oral submissions. This has also been identified in the ICC in its recent guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic, where it suggested that the parties should identify whether the entirety of the dispute or discrete issues may be resolved on the basis of documents only, with no evidential hearing. In this respect, reliance upon written submissions, while not ideal or even possible in all situations, is consistent with arbitration's emphasis on efficiency. Thirdly, we have the possibility of expanding global legal teams. The implementation of digital trends in international arbitration also allows legal teams or clients to have greater scope for constructing a truly global team which deals with and can defend its interests. That means legal teams can harness the benefits and skill sets from different jurisdictions and specialists from around the world without the need to be in person or have exorbitant travel expenses for those legal teams. We also have perhaps the number one benefit, which is the cost of the arbitration. It's fundamentally undeniable that digital hearings severely reduce the costs of the arbitration. That's from the hearing rooms to the arbitrator's travel expenses. We've all seen those receipts at the end of an arbitration where they're business class travel, and we all sort of giggle to ourselves about how much arbitrators are paid, and often dispute many of the receipts that we receive. But fundamentally, a digital hearing removes those barriers and makes it more attractive a prospect to parties who are looking for a speedy resolution to their dispute. If we look at the challenge just briefly, online hearings demonstrate the adaptability of the arbitral institution and arbitral proceedings themselves to flexibility. However, these same measures, if abused, could also present new challenges for due process and equal treatment between the parties. And Article 5.1 of the New York Convention, for example, an arbitral award may be challenged if a party getting the award is invoked was otherwise unable to present his case, or the arbitral procedure was not in accordance with the agreement of the parties, or even failing such agreement, it was not in the agreement with the law of the country where the arbitration took place. And that's really fundamental. The integrity of the award itself stems from a fair process based upon party autonomy and a party's reasonable opportunity to present its case. It's therefore almost unsurprising that emerging guidance, such as the Seoul Protocol on video conferencing in international arbitration, emphasizes that virtual proceedings must be fair to all the parties in dispute. So where does that leave us? Arbitral institutions have an important role to play in developing practices and protocols to coordinate this digital move. Most institutional rules grant the tribunal the power and the direct procedure as it wishes. The onus will now likely be on the parties raising an objection to a virtual hearing to explain why it would be untenable under pressing circumstances. Beyond this, there are a host of refinements and adjustments to be made to tailor to the traditional procedural safeguards to the virtual hearing setting. The questions remain: how will we address the concern for real-time witness coaching? Will the debate echo traditional discussions of the standards for witness preparation? Will we need to adjust the typical daily hearing schedule now that participants can expect to sit for long periods in front of a screen? And what should be done in the event of technical failures? These are among some of the practical issues that the international arbitration community will be considering, and on which proactive contributions from arbitral institutions will no doubt be welcome in the future. In developing new approaches, a number of existing soft law instruments will no doubt assist, although they don't necessarily directly deal with virtual hearings. They offer helpful guidance on examining witnesses by video conference facilities. For example, the Hague Conference Draft Guide provides an exhaustive discussion of best practice in relation to video link witness evidence. It considers factors such as time differences and operating outside regular business hours, introducing documentary evidence via video link, a protocol for speaking and interruptions, and where there is a delay between the picture and the sound, as well as advice on room layout, access, acoustics, and lighting. The ICC Commission report provides a sample wording for pre-hearing order for testimony to be given in a video conference setting, which could no doubt be adapted to virtual hearings and copes with issues of technological breakdown. So finally, the COVID pandemic has required us all to adapt rapidly and in unprecedented ways to this new reality, one in which has developed virtual hearings as the means for all our disputes to continue to be resolved. Fundamentally, the genius of arbitration and the international arbitration community is that of innovation. And we must all work together to advance the technologies and develop the protocols needed to meet the challenges ahead.
Thank you so much, Gavin, for that in-depth analysis of the benefits of arbitration, of the use of technology in international arbitration. There's one thing, and perhaps I'll put it up during the Q&A still, is whether the use of arbitration reduces the fees of arbitrators. I would love us to discuss that, and I'm sure there will be a lot of divergent views on that. Now to our last speaker, but not the least, from Cairo in Egypt, Tariq Badawi, will be telling us about the risk. Most of the speakers just before you came in have also identified in brief some of these risks that are involved in it. I've had the benefit of seeing your presentation beforehand, and I'd love you to give us some further and more detailed perspective into this risk, particularly since this is a great source of concern to many of the practitioners of arbitration across the world. Tariq, you have the floor.
Thank you, Idris. And I wanted to thank the co-panelists for their contribution. I will try to be as brief as possible, considering that some of the issues I was going to go through were briefly mentioned, and leave a bit of time for the question and answer session. Undoubtedly, these are unprecedented times. The COVID-19 pandemic has shaped or reshaped the way we think about our legal practice, arbitration not being an exception in that case, and forced us to adopt new means to resolve our disputes. And I'd like to quote Professor Muhammad Salah Abdel Wahab, because he really summarizes the situation we're in right now. Is that he says, in times of crisis, whether actual, receivable, or pending, time and money are of the essence. Hence, the need for innovation, as Gavin was saying, and tailored solutions. So Anna has in a very able way, explained some of the new technologies that we will be dealing with in the near future, as well as Nuno. I'd like to go briefly over some of the risks that come with virtual arbitration. So, the first one anyone can think of is technological illiteracy and unequal access to the internet. And I think there's someone here who can explain this much better than me. And I'd like to play a short video for that. So this is an example of a very basic example of the problems that we can face is technological illiteracy. Lawyers are traditional by nature, irrespective of their age or education. We are fairly square people. And I'm not sure we can always keep up with technology. So this would be an added layer on us lawyers. If the technology progresses very quickly. Now, fortunately, lawyers are also smart people, and so are arbitrators, and they can try as much as possible to catch up. But that remains a problem or an issue that is worthy of discussion. Another problem that is more of a technical nature is access to the internet. I have a map here. I'm not sure to what extent it's very accurate, but it still presents a phenomenon that we are faced with, is that access to the internet is not equal throughout the world. Now, in the context of local commercial arbitration in certain countries, that access to the internet may not be a problem. However, if we're dealing with an international arbitration, and I could think oftentimes of investor-state disputes between investors and states in the developing world, where access to the internet may not be as seamless as it is in other parts of the world, that could also pose a problem and disruption rather to arbitration, not necessarily an obstruction, but it could be disruptive. And another risk there have been several hacks. Systems can be hacked fairly easily. And right now, speaking on this note, I just received a note on my computer telling me that my internet connection is not stable. So that goes back to the issue I was mentioning a minute ago. So if I ever get cut off, I will try to reconnect as soon as possible. So back to the presentation. Cybersecurity remains an issue of utmost importance, and various institutions are conscious of that. Arbitration in general is a confidential exercise. If you look at the ICC rules, for example, Article 22, subparagraph or paragraph 3 states that upon the request of any party, the arbitral tribunal may make orders concerning the confidentiality of the arbitration proceedings. Similarly, the LCIA rules say that the parties undertake as a general principle to keep confidential all awards in the arbitration, together with all material in the arbitration created for the purpose of the arbitration and other documents produced. So confidentiality is a very important and attractive element in international arbitration. Now, this can be potentially compromised in the context of virtual hearings. And I'll give you an example here. A survey was conducted by a law firm in 2018 on about 105 practitioners, including arbitrators, experts, expert witnesses, counsel, and in-house counsel, spread all over the world, in most parts of the world, including parts of Africa, on whether or not they were subject to hacking. or whether or not they viewed virtual proceedings to be safe. And about 11% of the surveyed individuals, so we're looking at about 10 or 15 out of the 100, experienced a breach in arbitration. Bearing in mind that this took place in 2018, so that's pre-COVID times and pre-proliferation of virtual hearings. So if you look at that small percentage, and which is undoubtedly going to increase with the surge in virtual hearings, there would be a risk here that should be taken seriously. Now, examples of hacking, there could be access to video conferencing apps can be hacked, but one of the important results, or one of the things that must be considered, is that issues such as trade secrets, which arise quite extensively in IP and pharmaceutical disputes and know-how, can be accessible to third parties. Another issue that one should consider is confidential information of a state-like or intelligence-like nature that could oftentimes arise in state-to-state disputes or investor-state disputes. And the risk of hacking of this information can be quite costly. One can think of, in 2015, the Philippines-China maritime border dispute. There are reports that the PCA, the Permanent Court of Arbitration website, was hacked, and so was the Philippines Department of Justice and the law firm representing the Philippines. The websites of all these institutions was hacked by anonymous parties. Obviously, such hackers were able to obtain sensitive state information. There are also reports that in the ICSID case, Libananco versus Turkey, Turkey intercepted correspondence between claimants' counsel and third parties, which also demonstrates that law firms are primary targets of hackers. A survey was conducted by Logic Force, a cybersecurity consulting firm, in 2017, again, pre-COVID. Interestingly, it surveyed 200 law firms. I don't know what these firms are, but I assume that some of them are fairly well-known firms. It appears during the survey, after the survey was conducted, that all of the 200 firms were hacked, but only 40% were aware of such hacking taking place until the study was conducted. So, I mean, it gives you a sense that with new technology, hackers evolve as well and can potentially cause damaging effects. So with new technology, new protection mechanisms to be installed. The other issue that is fairly topical nowadays is data protection. Now with the GDPR in Europe and various other countries, PEPIDA in Canada and in Egypt, now we have a new data protection law that was enacted a few months ago. There is a lot of focus on the protection of personal information. So arbitration is not all about commercial secrets and trade secrets and the protection of this information, but there's also an element or a significant importance to protect parties to the arbitration. Personal data can be easily, simply defined as information that can identify a person. So that includes email, addresses, names, credit card information, banking information, family and personal status information. If this information is hacked, it could lead to identity theft, but it could also lead to threats to the personal security and family of parties to an arbitration. So think of, witness protection programs that you have in domestic dispute settings. There may need to be that as well in the context of international arbitration. I'm thinking of the safety of factual and expert witnesses in particular, but also of arbitrators who could be subject to pressures from hackers or who are aligned with a particular view. On this note, the ICC has taken it upon itself to highlight the importance of data protection. So in its note to parties and arbitral tribunals on the conduct of arbitration under the rules, paragraph 83 states that parties shall ensure that their representatives, as well as their witnesses, experts, and other individuals appearing on their behalf are aware and accept that their personal data may have to be collected, transferred, published, archived for purpose of arbitration, and that applicable data protection regulations, including the GDPR, are complied with. So this also emphasizes the fact that participants in arbitration are aware and have to consent to their data being disclosed to parties collecting it and processing it. On this note, if you look at all the privacy policies of cloud service providers, since cloud service providers are important in the context of online arbitration or virtual hearings, all these privacy policies clearly indicate that while they take all the necessary physical and technological measures to protect personal information, such measures are not bulletproof. There's always a risk of hacking. And that's also for liability purposes and disclosure purposes, but also for the protection of those granting or providing their personal information. They do it knowingly and bearing in mind that there's potentially a risk. And the risk can take several forms, but I'd like to mention a couple of examples of hackings that actually took place where personal information was leaked. And so, for example, Dropbox, which is very commonly used, was hacked in 2012. And it seems that based on the information that I got on the internet, that more than 68 million user accounts were hacked, including email addresses and passwords. That's in 2012. LinkedIn was hacked in 2016, where hackers stole and posted for sale on the dark web an estimated 167 million LinkedIn email addresses and passwords. Apple iCloud was hacked, and we know of some of the famous artists whose photos were leaked a few years ago. And Yahoo apparently in 2013 was hacked, and more than 1 billion user accounts are reported to have been compromised in the attack. So we're talking here about the most sophisticated service providers. Even those get hacked. So with online or virtual hearings comes the risk of disclosure of information. And as a result of that, it needs to be offset or compared to the benefits. I personally think that the benefits do outweigh the risks. But that said, measures need to be taken by technology companies to ensure that they remain as much as possible one step ahead of hackers. And I know that's not easy. Now, finally, and Gavin touched upon it briefly, there's the risk of fairness and due process. Arbitration, especially the procedural aspect of it, is exclusively dependent on the lex arbitri, the law of the seat. If the law of the seat is not flexible or does not allow for virtual hearings, then there will be a problem of enforcement, and issues of annulment would arise. Unfortunately, we can't, not all legal systems are developed, not all legal systems are technology friendly, and we're still in the early stages in the COVID era right now. We're still in the early stages of applying in a much more extensive manner the concept of virtual hearings and online arbitration. So I do predict that there will be some surprises in the future where some courts in certain jurisdictions will annul certain awards because they were done virtually, and those courts did not deem virtual hearings to be compliant with the law of the seat. Now, on this note, institutions have adapted very quickly. Institutions are typically quite fast. The ICC has notes on virtual hearings. It actually, in Article 25 of the rules, it says that parties can, the recommendations, ICC recommendations say that parties can, where possible, use audio and video conferencing services, while Article 25.2 of the rules says that the arbitral tribunal shall hear the parties together in person if any of them so requests. But in the ICC guidance notes, ICC made it very clear that the term in person does not mean physically in attendance, but it means that the parties will have the opportunity for a live adversarial exchange. So that provides a good balance to allow virtual hearings, but also in a manner that does not compromise the fair and progression of or conduction of the arbitration. Similarly, Article 19.2 of the LCIA rules provides for virtual hearings, but also here in Africa, Corsica has issued its recommendations a few months ago, the COVID-19 related recommendations and practice notes, recommending the holding of virtual hearings. And actually nowadays, most lawyers and arbitration practitioners in Egypt are engaged in one or more arbitrations conducted entirely online or virtually. Now, Anna mentioned the very promising Austrian Supreme Court decision that allows for the recognition of virtual hearings. I have here two examples, one from Holland and one from Hong Kong. Based on secondary material, it appears that these articles are interpreted in a way to allow for virtual hearings. And I'd like to pause for 1 minute, considering I practice in Egypt, on the Egyptian context. Now, Article 25 of the Egyptian arbitration law says that in the absence of the agreement of the parties on the applicable rules, the tribunal may, without prejudice to the provisions of the present law, adopt the arbitration procedures it deems suitable. Now, the wording here is very, very broad. In theory, this means that if both parties agree to a physical hearing, then the arbitration, the tribunal is compelled to hold a physical hearing. However, if one or either parties or both agree to a virtual hearing, then the arbitrator has the discretion, the tribunal, has the discretion to proceed virtually. Now, I'm asked to wind up, so I'll just speak about the last slide and then I'll wrap up. But Egyptian courts have been quite flexible, is that they have allowed virtual hearings through the back door. So the first one, through two back doors basically. The first one is that courts in Egypt defer to institutional rules. So there's rich jurisprudence on the issue where if the parties choose to apply institutional rules, these institutional rules will prevail over the Egyptian arbitration law to the extent they don't offend public policy. Now, most institutional rules now, including Corsica in Egypt, allow virtual hearings. So we don't have that problem in Egypt. And secondly, there's a very recent decision from 2020 by the Court of Cassation, which is our Supreme Court, making that clear distinction between the venue and the seats, and stating, albeit in a very subtle manner, that since the concept of the seat of arbitration is an abstract idea linked to the actual venue, abstract idea is not linked to the venue of the hearing, then there's no problem effectively. So what the court says here is that if the law of the seat is Egyptian law, for example, there's nothing that prevents parties from conducting the hearing in any other jurisdiction, physically even, that will be the venue, or online with parties scattered all over the world, provided that the procedural rules, not rules, the laws of procedure to apply will be the laws of Egypt. But if the parties choose a foreign venue or conduct their arbitration in the virtual space, this will not affect the validity of the award for enforcement purposes. I'll wrap up here. I can discuss remedies and other risks in the question and answer session. Thank you very much.
Idris, you're still muted.
Oh, thank you so much. I hope everyone can hear me now. Okay, then. Thank you so much, Tariq. That was a very in-depth analysis of the risk involved in the use of technology across board. We have just about 15 minutes to take the questions that have come up, and we've allowed so that we'd have a learning experience rather than looking at those questions as they come. So I'll just quickly dive in. Some questions have been put up to the Woover platform, and I'll be directing these to Anna. It's something you touched upon while you're delivering your presentation. And the question is, should technology-related disputes be removed from courts and sent to specialized dispute forums? Your thoughts, Anna? 2 minutes, please.
It is a very interesting question. Removed from courts, for me personally, sounds too strong. I think one of the great benefits of arbitration is that it is up to the party's discretion. And I feel like we should still give parties that choice. I feel like giving parties the option that they have an alternative to the classic court system that they can go to is great. But I wouldn't want there to be a mandate that says, this is a high-tech dispute, it cannot be before a state court. Especially because we have learned from Nuno in his presentation today, there are many courts who are quite advanced with their technologies and are able and willing to adapt to modern day requirements and to cater to those needs as well. And I think what we should strive for is not necessarily this thinking of, is arbitration always better, or is litigation always better, and should we force certain disputes only in one category, but rather providing parties with many options so they can really choose which option caters to their need the best.
Thank you so much, Anna. I'll be directing this question to Gavin. Gavin, what are your thoughts? It's also a question that came up on the Woover platform. What are your thoughts on inserting arbitration clauses into smart contracts?
I think it creates an interesting dynamic in terms of dispute resolution generally. However, sometimes the problems with that is it perhaps doesn't allow the bespoke nature that we're used to as practitioners because of the prescriptive requirements that may pertain to inserting that into a smart contract. So I can see the benefit perhaps in future, but I don't yet think we're at that stage where the bespoke nature of arbitration clauses, which is something that clients routinely ask for, would be necessarily the right forum for that just yet.
Thank you. No, you mentioned about when you started practice, it was all about the pen and pencil and paper. I was just wondering, this is like a personal question, how you were able to manage the migration from pen and pencil to the computer, because you've given us a very brilliant paper on new technologies, and one would never have known that was where you started from. After that, I'll now ask a general question, which I want the thoughts of everyone. And this comes up from the presentation made by Gavin. And that is, does the use of technology actually reduce the cost or the fees, or let me put it straight, the arbitrator's fees, which a lot of the general consensus out there is that it's quite high and very expensive. But I would like Nuno to give us his own personal experience of his migration from pen and paper to computer, and then the thoughts first from Tariq on the use of technology on the reduction of arbitrators' fees.
Thank you, Idris. How I did the immigration. When I left the university, I never heard about a computer. I didn't know what was a computer. Okay. When I arrived to my law firm to the training, the colleague which one I trained liked it to have the things in a right machine. So I started to do it in a right machine because I didn't know before writing in a right machine. And we start to learn about computers and how they will change the world. And after in some years we don't need more books, and we will have all the codes, all the books in the computer. And this was something very, very far away, and we didn't understand. And it was my fault, and in the law firm where I was training, to start with the immigration with the computers. So I convinced my colleague, the partner of the law firm, to buy the computers, to buy a web, internal web. So we started like that. And I started to do the things in the computer. So the things in the next years, it's what you happen. I talk you about the book of Richard Susskind. It's very interesting. If you read it, the other book he wrote 20 years ago, if he said, the email, which will be the must thing, the must way to communicate between lawyers and the courts and everything. And many people in that time think it was crazy, something crazy. So the time is changing, and we must adapt it. And let me share one last thing. My father was 70, almost 70 years. He bought a computer and he died writing in a computer. He was a writer. He's a Mozambique. He was born in Mozambique, and he liked to write many things. So my mother, in 1980. He asking, I want to buy a type machine. And I say, you don't buy a type machine, you will buy a Spectrum. Do you remember the Spectrum? It was my first computer. It's why I do the immigration.
Thank you so much, Nuno. Blast from the past there. So Tariq, do you think the use of technology would reduce the fees of arbitrators? Please don't tell me yes. Tariq, you need to unmute. Tariq, you need to unmute.
I don't think, well, I mean, it will certainly reduce certain costs, business class tickets, as Gavin was saying, and some fancy meals. That will definitely be, will disappear. However, with sophisticated technology come expenses. So costs will be spent on software, will be spent on protection mechanisms, will be spent on other matters. So while, and you know, I don't know, they may be charged by institutions indirectly, because these institutions, in institutional arbitration, would need to take all the necessary, you know, they will subscribe to certain tools and certain software, etc., which will cost a lot of money, and that could reflect eventually on the administrative fees of the institution. So I'm not sure if the entirety of the costs will decrease, but the distribution of the costs will change for sure.
Thank you. Gavin, your thoughts? You inspired the question.
Yes, I think actually my view is that we might get a hierarchy system in arbitration, in that we'll have those that use a online system, and that obviously has lower fees, and those that have an in-person system. I think the danger there would be perhaps that parties perceive that one version of the proceedings is better than the other, and then we have a creation of a new hierarchy in the system. I think that's an interesting development moving forward. But I think the way that things are moving, I hope that the fees of the arbitrators reduce, and therefore it encourages this means of dispute resolution.
Yes. So, with any other thing, just to say a very big thank you to the organizers of the second annual African Arbitration Association Conference. I've had a great time, and I'm sure everyone else too. So we still have like 2 or 3 minutes. So I'll just take last words from everyone on this session. I'll start with you, Anna. Last words.
Thank you very much. I think those were very inspiring thoughts from my co-panelists. To answer your last question, when it comes to costs, I do think there is a chance that overall the costs of arbitral proceedings will be lowered through the integration of use of technology. I think it's not necessarily only the online hearings, although I feel like those can be a cost driver both ways. While you can have a physical hearing blocked 3 days, 8 hours, you can't necessarily do that online because it's a little harder for people to pay attention. You might have time differences, so you might have to spread your hearings out through multiple days. So I think online hearings can decrease cost when it comes to travel, but also increase costs because you might have to spread it out. But through the use of artificial intelligence and the other technological tools that we have talked about today, I think overall there's a good chance that the costs of arbitration, not necessarily the arbitrator fees, but arbitration as a whole will be reduced.
So thank you. Finally, thank you everyone. Gavin Dingley, Anna Fostel-Sheng, Nuno Albuquerque, and Tariq Badawi for spending your time, for sparing us your time and giving us your thoughts, very elucidating thoughts and very deep thoughts and analysis of the topic at hand. I'm sure our attendants and the participants in this session would agree that they would be leaving these
Idris, you're muted.
On high tech in international arbitration and its risks. So thanks to the organizers and thank you to all the panelists too.
Thank you.
Thank you. Bye-bye.
Thank you.